How to file a trademark application without a lawyer. Welcome to Legally Flick by Anik. My name is Anik Koloko. I am a business attorney, and today I will show you how to file your application without a lawyer. Now, the first thing that you need to know, the agency that is in charge of processing application, trademark application, is the USPTO. As you can see, the United States Patent and Trademark Office. In that you will have to go to this website to start your application process. And then obviously, all of the application always start with a trademark search. And at this point, you have to start with your trademark search. And we will start by using what is called TESS, okay, which is the Trademark Electronic Search System. That's basically the acronym for that. Although this is not an exhaustive search, this is a very good point because once you start there, you will see all of the trademarks that are currently registered with USPTO. That would be a very good start. Obviously, once you start, and if you believe that you may not have conflicting search, it's always good practice actually to have a more thorough search. This is only the beginning. And also a caveat, remember that you do not need to have the exact name, the exact spelling, because remember, every time you perform a search, put yourself in the shoes of your consumer. Will you be confused? Because that's basically the policy reason why, obviously USPTO will be either approving or denying your application. They want to protect the consumer. They want to avoid the likelihood of confusion. This is the big one here. This is the most important rule that you need to remember. Will your consumer be confused if they run across your mark? That's why, even though you may not have the same spelling, you have to remember, will your consumer be confused? Does your mark sound the same to another mark that is already registered? Does it look the same? Here we're talking about color. Remember that trademark can either be a sound, can be a color, can be a tagline. When we're talking about a sound, you guys remember probably Netflix, right? Netflix, the chimes of Netflix has been trademarked. That's very important for you to know. The color, remember the Tiffany blue. The Tiffany blue has been trademarked. Remember, also think about UPS, right? The brown of UPS has been trademarked. The smell also can be trademarked. The smell of Play-Doh, that has been trademarked as well. Now, the company that has been using trademark in a very, very clever way is Nike. Because you have the brand name, you have Nike, then you have also the slogan, just do it, right? And then you will see the logo, and that's the swoosh, right? Those are all the way you can protect your mark. And it's extremely important because you will see that the mark, the trademark, your intellectual property, the intellectual property of your company is the most important asset. Whether it is about selling, obviously, your brand to maybe a competitor, or maybe you're associating yourself, or maybe you're just an up and coming. But how do people obviously recognize the brand? How do your consumer recognize the brand and they know for certain that this is the quality, these are the property that they associate with your brand? How do you make sure of that? This is what trademark does. Trademark is basically a conversation between you and your consumer. Meaning basically, for example, let's say you're using an iPhone, right? How do you know that it is an iPhone? It's because you see the logo, you see the trademark of Apple, and they make a lot of effort. They put a lot of effort for you to trust the brand. That's why you will see that the most valuable brand in the world are Google, are Apple, and we're talking about evaluation in the billions with a B. of dollars. That's why you will see that it's very important once you try to obviously make a search and you want to register your mark. Please do not skip that. This is very important for you not to skip this phase, because you may go all the way to the process, which is already taking almost a year, just to have a rejection because your mark is too similar. And the trademark examiner will be raising that issue by telling you that there is, quote, a likelihood of confusion, unquote, in the mind of the consumer. Meaning this is the part where you really should slow down, because even worst case scenario, even if you decide not to trademark your brand and you start using your brand, you may find actually an infringement lawsuit from a third party claiming that your mark is too close to theirs. This is very important. That's why trademarking and even searching is so important. And also, do not be confused or feel comfortable that because you do already own the domain name, or maybe because you register your application with the Department of Corporation in your state, means that you have actually ownership of this particular brand. No. Because if now a third party come and raise that issue of the likelihood of confusion, they have the right, actually, they're entitled to go to federal court and basically, request from you that not only you pay damages and as well as attorney fees. They're entitled to that. And then you will have to start the process all over again, whether it's on the social media, whether it's online or physical, the rebranding, and that could be quite costly. Meaning trademark has this way of affecting everybody because you cannot obviously exist without it. But without further ado, this is just a little introduction to show you why this is important to start your search very, very carefully. Now, once you enter here, you make your search. Obviously, if you're satisfied, we're assuming that you're satisfied. And if that is the case, we will go now to, obviously the application itself. Now, let me show you how does it look like once you go onto USPTO website. And then that's actually, obviously, an application, meaning that you create it. And then don't be also confused, because you will have to create an account with USPTO. That's very important. You cannot just go to the website and immediately start applying, submit your application. That's not the way it goes. It's actually it's more complex than that. You will have to make sure that you do have obviously an account, and then that you create this account, and then obviously once you do that, then that's fine. Okay, now the first page, once we start there, and obviously we have to look at the first page, and we can see that the first page, when you look at it, you can see that you have to go to the first part. There are two types of trademark application. There is what is called the TEAS, obviously, and then TEAS plus. And that's very important when you see all of that, to see that you have the difference. The TEAS and the TEAS plus is also the fees, because the fees is quite important, and you have to look, at how will that look like. Now, for the TEAS in plus, you will see that there is a $250 application fee, and that will be per class. And you will see when we talk about per class, is because USPTO has a classification of the goods and services, obviously, because they need to know to classify your goods and services. And depending how do you want to use your goods and services, you have to tell USPTO what type of class are you trying to use. Now, if you decide to use what is a TEAS standard, then it's a $350 per class, and for goods and services. Sometimes the TEAS standard may be something that you decide to choose. Obviously, that will allow you also more flexibility, but this is a decision that you will have to make at that time. Now let's go to the second part where they're asking if there is an attorney. You can see here that we put yes, but if it's not, if you don't have an attorney, then you don't have to, obviously you click no. But if you know that, okay, you do have an attorney, then the attorney will have to fill it out. But for this example's sake, that will be a no because you are the one filing this application without a lawyer. Now you will see that on number 3, you have to upload a previously saved file. This is basically if you have a file that was saved previously, but for example's sake, you do not have that, we're starting from afresh. Now the second part then is pretty straightforward because this is actually regarding your information as an applicant. Now you have to decide who is the owner of the mark. USPTO will like to know because remember, we're talking about intellectual property. Who is the owner of the mark? Is the owner you, the individual, or is the owner actually your company? And this is it's a big distinction here because if it is the company, you need to explain, obviously to provide it. You will see that you have a choice, right? Whether it is an individual, if that's the case, corporation, and you see the list goes on and on and on. Because legally, those are different legal status, and you have to decide. Let's now, assume that probably you're filing as an individual, and then you can always change that later, but that's beyond the scope of this video. Then let's say you will put here, here obviously owner of the mark. Then you will see Mr. John Smith, and you will click here for individual, right? Now you have to provide, obviously there is a drop down here, and it doesn't appear here, but there is a drop down menu, obviously, but you have to choose at least what is the type of ownership that you have. But for this example, we say you are an individual. Now you're moving on and you're entering the mailing address, which is 123 and then Main Street, as well as the city and the state. Now, as an aside, sometimes people are quite surprised. The USPTO are public record, and the reason they are public record is because it is a federal agency, and under the law, they have to provide that information. It has to be obviously public, and this is something that you have to remember, because when you provide your domicile address, if you do not have a mailing address here, the domicile address will appear. And that sometimes can be startling. And you can see they're telling you uncheck this box if the domicile address and the mailing address are not the same. And if you do that, you uncheck, then your domicile address, your private address will be actually hidden. And the only address that will appear will be your mailing address, which is a good thing. Now, keep in mind that if you are filing as a corporation or either an LLC, a trust, and so on, but not as an individual, the good thing is at least your legal entity will have their own address, and you may avoid this particular issue as far as confidentiality, privacy, and so on and so forth. Now you're entering also your phone number, your fax number, and that's self-explanatory, as well as the website. Now, this is the part where it can be a little bit confusing and maybe a little bit dicey, because this is the part where you have to describe the mark, right? What is your mark? And you can see it's titled the mark information. Now, there's different type of mark. USPTO have different type of mark, the way they classify it. You have to select whether it's a standard character, whether it's a special form or a sound. Now, I'm going back to the example of Nike, right? If it was Nike, for example, completing this form, the standard character will be the word Nike, right? But if it was a special form, let's say we want to protect the logo, right? Meaning that you want to submit an application for Nike logo, you will not choose a standard character. You will choose a special form because it's stylized or designed. And you can see that They give you the information. That's the thing with USPTO. It's chock full of information. It can be overwhelming, but it is there. You can see spatial form. They say the mark include a design, right? Or a word displayed in a particular font, style, size, color. For the example of Nike, let's say we just choose the logo, the swoosh. Then you will choose that. Now, if it's a sound mark, that will be different. Remember the example about Netflix and the chime. They will check here for sound mark, and then obviously they will have to upload the sound into the system. Now, once you do that, you have told USPTO what type of mark are you submitting here for consideration. Then you have to describe, you have to enter the mark here. And this is, for example, again, going back to example of Nike, then you will enter Nike. And if you click, you will see the generated image by USPTO, which is basically a standard font, the way your mark will appear even on your certificate of registration. That's basically what this is. Now, then we have to go at the end here of the page. It can be a little bit, more, if you want to be a little bit more detailed. If you have additional statement, right? Let's say your mark is not as straightforward, then you may want to add some additional statement. Then you should obviously check here to display for additional statement. And you will see that when we say for additional statement, then you have, they say claim, for prior registration, translation. Translation is quite an interesting one, because if you remember, is that we want to avoid a likelihood of confusion. And sometimes people believe that they can go around that by probably having a mark, in a foreign language, a brand name in a foreign language. However, you have to disclose if you have a brand name in a foreign language. This is where you will have to click for an additional statement, and you will have to tell USPTO what is the translation in English of your brand name. And now, if the translation in English is similar to a mark actually in the English language, you will have a hard time overcoming an objection from USPTO. Why? Again, put yourself in the shoes of your consumer. Will the person be confused? Because you may think, okay, not a lot of people are speaking this particular language in the United States, but you may be mistaken. You may have a consumer encountering your mark who actually is quite versed in that particular language and may assume that, oh, this is the mark that I know under this particular name in English, or they're having this new version in this other language. And there you go, you have the likelihood of confusion, meaning that this is why USPTO will actually want to know, and you have a duty to disclose, they will want to know actually what is the translation of this particular name. Now, you also have some example. For example, if you put the name of someone, right, you need also to show to USPTO that the person gave you consent, because obviously you cannot use the image and the name of somebody without their consent. Even if it's a family member, even if it's grandma will have to sign. And then you have to also specify whether the person is alive or dead. Obviously, you have to make sure that you want to provide that information, and that allow USPTO, the trademark examiner, to make a decision, obviously based on all the information. Because after all, when you submitted your application, it is a legal document. And when you sign, you're signing under the penalty of perjury that you have actually submitted all the information required for the trademark examiner to be able to provide, obviously, a good legal analysis and decide whether your application should be registered. This is important. Now, let's say you're done here. Now you're going to the following page. And the following page, again, here we're talking about, is continuing with the mark information, right? Now you have to decide at this point, once you go, you decide to go there, you can see that they're asking you, obviously, you have to attach, obviously, a picture here, because you can see that they're telling you that click and the button and select, obviously, a size and image of the acceptable form of your local drive. This is basically this. They are talking about image showing the type of product, right? Because you have to um, actually provide information and show to USPTO exactly the detail about your brand, about your mark. And this is where you have to describe how it looks like. Now, let's assume, for example, that we're still going back to the example of Nike and the logo, right? We have the swoosh. Let's say the swoosh is blue, like a dark blue swoosh, and then it has Nike underneath, or it may not even have, because a logo could have word or just have the design, meaning that you will have to decide exactly how it look like. But now, if that's the case, let's say that we decided our logo is dark blue. You will have to explain here that the color blue, right, and you describe, are claimed as part of the mark, meaning that you're going to have to find the perfect word to actually describe the mark. If, for example, you decide, no, I'm just going to have a logo, but the logo will not have a particular color, then you may not want to complete this, right? It's very important, because if you don't do it, then it may be rejected, or maybe you will receive a letter from the trademark examiner asking you to really, complete, to provide more information. And the reason this is important is because, again, the likelihood of confusion, remember, put yourself in the shoes of the consumer. When they encounter, not only is the sound, but is also the sight. If it looks closer, like there was a famous case of actually Starbucks against, I think it was a corporation, much smaller. And I believe in one of the states, I think on the west side, the west coast of the United States, even though it was not called Starbucks, but the design, the imagery, the color were quite similar, meaning that the person, without even looking, whoever will be encountering the mark, like unconsciously may associate the mark with a more known mark such as Starbucks. And this is why this is important. Are you claiming that? If you're claiming by saying that, no, these are the color of my mark, then they would like to know that, because they will make a search to see whether your logo with the color that you claim is similar to one that is actually registered, and that could trigger a likelihood of confusion in the mind of the consumer. And this is important. Why? Because at the end of the day, what USPTO is trying to do, and don't forget, they are part of the Department of Commerce, they want to make sure that there is a fair marketplace, right? Where the consumer will actually make his or her purchase, without being actually confused or influenced. And sometimes there are some corporation that will actually move forward and create some marks that are quite similar, just because they want to siphon consumer from a more established brand. And that's what USPTO is trying to avoid here. That's why you have all of these questions. You just have to think about that. There is always a reason. When you see a legal document, as an aside, with all the questions, there is always statute, and then on top of that, there is a policy reason. Always remember why, what's the reason, and that is the reason. Now, you will have to see, obviously, we will see, as far as, attaching, we talk about to describe, obviously, then we have to see, we see that we have already described our mark and our brand. We talk about that. Now let's move on to the good and service information. Yes, you want to file your mark with USPTO, But now you have to tell USPTO what type of good and service, right? Because there is a list, obviously, of good and service that fall under this particular description, and you need to tell them why. And you see that here they have this information explaining you exactly what does that entail. And you will see the first step, you will have to click here on add good and services. Let's say, for example, you are an online store selling clothing, right? Once you click here, you will have a drop down. You will be taken to another, tab where you will see, and it's still on the USPTO website, you will see a list actually of goods. You will have to enter the type of good. Let's say in our example, the type of good will be, let's say, t-shirt, right? Then if it's t-shirt, once you enter t-shirt, you will see that on t-shirt, it will tell you, obviously, the different type of t-shirt, where there is, you will have regular shirt, sweatshirt, press shirt, and so on. And mostly that's class 25. You will have to decide, okay, this particular description come very close to the description of the type of good and services that I actually would like to be protected, right? If that's the case, if you find out, okay, it's a regular t-shirt for men and women, then yeah, sure. Then at this point, you have to click that and it will auto-populate at this point. Now, if you make a mistake, don't worry. You can just go and remove the check good and services. You will see is pretty much, straightforward. And you can see they even have a video explaining, but it's very important that you choose your good and services very well, because if you fail to do so, you may have trademark protection on a certain type of good and services. But if you forgot to add the other type of good or services, that would be an issue. For example, let's say you selling clothing, but then at the same time, you decide that you also want to sell probably shoes or something like that. That's not the same class, right? Or maybe you decide that you may want to sell maybe perfume or something like that. That's a different class. You need to choose not only the class 25 for your clothing, but then you may have to move also to class number 3. That's 2 classes. If you don't do that, then you will be limited. Obviously, you can always, submit another application, but you may want to be as thorough as you can, because every day you have new applications submitted to USPTO, and somebody can actually, submit an application and filing an application basically targeting exactly the same good that you wanted to have. I mean, that's something that can happen. And if the person can prove that there is no likelihood of confusion, because you also have, beyond likelihood of confusion, you also have to be able to demonstrate that those are different channels, right? Meaning somebody who is selling a particular type of goods, and then somebody who is selling something that is very different. The example that comes to mind, Dove chocolate, right? And you see also Dove soap. Why are they allowed to coexist? Because it's 2 different channels. Because the way USPTO make the analysis is that consumer looking for soap are basically using different channel. Even the marketing will not be the same as the people looking for Dove chocolate, meaning there is no confusion in the mind of the consumer. It's completely 2 different type of good, very distinct. That's why you have to be careful when you do that. Think about that. Try to be thorough in your application. Now, as you can see, we're talking about, how you make your search. This is how it looks like, meaning that you go, you make your search, you enter here, and then you go from there. Then once you click, it will give you more example. Now, you go into this particular page, and that's called the basis for filing. Now, the basis for filing is quite interesting, because you have to tell USPTO exactly what is the basis. USPTO wants to encourage commerce, meaning that you do not even have actually to demonstrate that your goods are already being sold. You can file under what is called intent to use. If you file under intent to use, it's perfectly fine, but you just have to explain that to USPTO. But if you already have your goods in commerce, then you will have to say so as well. Now, let's see here. As you can see, we already spoken about the how to add the goods and services if you need to remove them. When you add goods and services, it will appear here, right? Let's say, like our example, you selling your t-shirt is going to be international class, is going to be class 25. And it's going to say here, t-shirt maybe for men or women, depending what you check, right? But now you need to tell USPTO what's the assigned filing basis. It's very important. You have 4 choices, right? You can file under Section 1A. If you file under Section 1A, then obviously it means, as you can see, that you're already, selling the goods, they're already in commerce. And in commerce, obviously, you're looking for federal protection. It means that in commerce in more than 1, even 2 states, because you have to show interstate commerce. Now, if you go to Section 1B, then it means that that's the intent to use. It's not in use yet, but you're intending to use it pretty soon. Then you will choose Section 1B. Now, there is also, the case of what is called a foreign application, right? Because you have to remember that the United States is part of what is called the Madrid Protocol. I mean, this is a protocol between the United States and other foreign countries that allow you actually to file an application with either country based on a previous application in one of the signatory country. Now, what does that mean? You can see here, they say Section 44D, the foreign application exists for the same good and services. Let's say, for example, you are filing from Canada, right? You already have an application in Canada. Then you will have to choose that to tell USPTO that you already have an application in Canada, for this particular good and services, the same brand. And that will be the basis of filing, meaning you basically, going globally as you should, because nowadays the world is quite, the world has no borders with social media, online business. Or either if you choose Section 44E, it means that then that's even a step further. You're telling USPTO that there is a foreign registration for goods and services. And this is quite interesting because sometimes if you're not careful, when you perform your search at the beginning, you may have a search and then you just look in the United States and it looks like everything is fine. But actually, because your search did not include other countries in the Madrid Protocol, you may have somebody that has a brand that is quite similar to yours. And this person, even if they file after you, the fact that they will be claiming Section 44E, they could come actually and challenge you, right? And then just basically oppose registration because they can demonstrate that they already filed before you. And you will be surprised because you'll be like, no, I did file my application before USPTO prior to this third party. Yeah, but they can claim actually previous registration in another country based on the Madrid Protocol, and that gives them actually precedence on yours. This is something, it's not that common, but it is actually something to consider even when you make a search. That's why to skip on the search or not really making sure, it may be quite costly. You have to be thorough. Now, going to the next page, here, and then obviously once we have the basics of filing, then this is the part where you already chosen, you have to attach a specimen. This is basically applicable if you have a use in commerce. If you're already using your brand, then obviously you have a specimen. And the specimen, they can come in different shape and form. You have to attach your specimen here, and depending whether it's a online store, you're selling clothing, or you're selling physical product, you will have to do that showing the mark, right? And it can be quite technical. And if you do not submit the appropriate specimen, then you obviously going to have a letter from the trademark examiner asking you to resubmit. You can also submit a web page, right? You can submit a web page. Let's say you have an online store. You can submit that, you enter the link and then the date you access that particular link. And that allows the trademark examiner to go to your website and look and see exactly how the mark is actually used and whether it's affixed, meaning basically what does your consumer see when they come onto your website, and how can they go through the wholesale process? That's very important. And then there is also a question here, because if you say that you're already using your mark in commerce, then obviously you have to enter the date, when did you start using the mark anywhere and when it was used in commerce. Sometimes it's the same thing, it's the same date, but sometimes it may not be. You may have started using the mark in commerce, but maybe you were not selling, but you're already having this mark. And then when you started selling, that could be two different dates. Really, it's basically up to you at this point. You just have to let the examiner know by completing the application. And then obviously here, now we still with the basis of filing. As you can see, you have to check here that you understand, meaning here they're assuming that everything has been clean, it has been filed, the specimen have been uploaded. Don't forget, because sometimes if you forget to check that you understand that the section 1B is intended to use, obviously, because this example, this application, then it was submitted. Obviously, the applicant is making a declaration that they do not use their mark for the moment. If they do not use their mark, meaning they did not submit a specimen, and that's why they say remove this 1B, because it was on the section 1B. But if they want to remove, if you think you made a mistake, no, I have my specimen, then you just remove this, and then you will have the choice again here, 4 choices, and you will click on the one that is applicable, maybe section 1A, because you are using it. Now let's go to the next page. And then again, then we have to see, as you can see, the country, the region. This is basically, they're giving you several examples, because this is basically an example. As you can see, if you have for example, if you see that, okay, you're choosing, right, in the section 44D or 44E, then you say for 44D, for this example, the person is actually claiming that they have a foreign application pending. Then USPTO want to know, okay, what is the country and jurisdiction? I gave you the example of Canada. Then you have to click here. What's the application number, right? Then you have to enter it, and the foreign filing. That way, it allows USPTO to verify and to see whether you can claim the similar date. Because if you have a foreign application that is pending, then you can claim that date. Or even if you have a foreign registration, you will claim that date, even though you are filing, at a later date with USPTO. Then you can see here, then obviously 44E, they're giving you an example for 44E. In this case, you're claiming foreign registration. Okay, sure. Then you have to choose the country, and then the registration number, and then the foreign registration date, okay? And then the registration renewal, if that's applicable to you, and so on and so forth. Again, for the same reason, right? Because this is the basis of your application. Remember, we're still on the filing basis, and the reason you have the page seems to be repeating itself. It is not repeating itself. It just goes through several examples, whether you're using it in commerce, you're intending to use, you're claiming prior filing in a foreign country, or you're claiming prior registration to a foreign country. Now, this is actually almost the end. Thank you to actually still being here following this. Is actually this part where if you have an attorney, then this is where the attorney will have all of this completed, information about the attorney name, the bar number, and so on and so forth. This is pretty much self-explanatory. But for example's sake, you guys won't have this because you have chosen from the first page that you are not represented by an attorney, then this page will not appear actually. And then obviously we'll see, this is particularly toward the end, USPTO wants to know where to send correspondence. Remember now, 99.99% of applications are submitted online, and this is why they're asking you for correspondence, the primary email and the secondary email. When you have an attorney, you have the attorney email address here and the secondary email for courtesy copies are actually your email. That's what is provided. But given that you will be representing yourself, you'll be filing this without an attorney, then primary email address will be yours. If you have now a partner, a business partner, you may want to have that copy. Or if you have more than one email address for your company, you may want to have courtesy copy to make sure that it is received. And then obviously this is the basically almost the last page. This is a declaration because it is a legal document. Remember, you asking USPTO to register your mark, and you basically swearing that all the statements in the application are true under the penalty of perjury. And that's why you will have to click here, click there. Basically, to summarize, you are swearing the truth of the content of this declaration, and you are aware that number one, you will not be reimbursed once you pay the processing fee because you're paying for a trademark examiner to review the application, and it is not refundable if your application does not go through. All of this is basically self-explanatory. You can read a little bit about that. And then you can see here, every time you see some red star, it means that those are mandatory fields. The signature is important. The date is important. And you see the signature, you will see that you will have a / your name and another /, okay? And because you don't have an attorney, then you will see that you have the signature, then you have your name and the position. If you are the lawyer will enter your attorney of record. But because you will be completing this without an attorney, you see, they're telling you exactly. You can put general partner if you have a partnership. You can put, if it's only you as an individual, then you just put owner, right? Meaning, you see, they have enough example, and you just choose one of the example that's applicable to you. And then obviously the signature, phone number, you need to have your phone number entered here, just in case if the trademark examiner or either any other employee of USPTO would like to contact you. And that happens sometime when the trademark examiner just have a little question, and they maybe regarding the description most of the time. They're like, oh, I believe that we should add this particular word, and they don't want to issue like a full-blown office action. And if they can have you on the phone, then that can be solved very quickly, meaning that just make sure that you have a number where you can be reached. And then you can see that it's actually, you see the fee, you can see the number of class, right? Do you remember the example that I gave you previously? If you are an online business, you're selling clothing, and then you're thinking, I maybe want to sell also perfume. That's 2 classes, right? And it will auto-populate. You don't have to overthink. The system will calculate this for you, depending on what you have chosen as far as goods and services. It will calculate here, and then fee per class, it will tell you whether you've chosen the TEAS or the TEAS plus. It depends. Then it will be added, and you will see what's the total fee, right? And for the signature information, we talked about that before. You can sign directly, or for example, if you have a second party, they can send the text by email and have the person sign. But if you're the only person signing, or either even if you have an attorney, most of the time we just sign, we just click here and we sign directly. And remember, like I told you previously, you enter your name, the position, right? If you have, joint owner, then owners plural, but then it means that if that's the case, that's two signature, and then obviously phone number. And then that's the same page again, because when they're showing this to you is because you can have more. If you have more than one owner, you're going to see this page twice because the second owner will have to sign. And then obviously, this is how it looks like, because they want to show you, okay, they say, okay, because you can review and you should review your application before submitting it. And you have the choice to have this either as an input, as the mark, obviously the specimen, the file, meaning that the text form, and you click and you choose how you want to do that. And then obviously, if you satisfy, you see like, okay, everything looks good. Don't forget to check here as well, right? Because important notice that you have read, understand the above notice, please check the box. And then you have to pay and submit. And once you click at pay and submit, that's where it will take you to another page that will not be on the USPTO website. It will be, again, on the US government website where the Department of Treasury, when you will see a white pages, obviously with the fee that is due, and it will tell you that is for your application, your trademark application, and so on and so forth. You enter your banking information, your credit card, because that's what is actually accepted as form as payment. You enter your credit card information, and once the credit card is processed, you will receive a copy and confirmation automatically in your email address telling you that your application has been received, that the payment has been received as well. And that is very important because that number that will be included in the email, this is the number that has been assigned to your application. You'll be able to track the application. They have several ways actually to do that. You can either go directly to the USPTO website and make a search, like trademark search your application, even by application number, because you will see that. And then you will see that once you look at the page, you will see that there is TSDR. TSDR, once you click on it, it's going to give you information about all the documents that were submitted to USPTO. And you can see every time something has been submitted, you will see it will appear. Everything is electronic, is very convenient. But you want to make sure if you don't want to do all of that, just, don't worry, just call USPTO. And by calling USPTO, then you should be able to have, at this point, then that's okay. You should be able to talk to someone, and they're very, very helpful, and they will be able to let you know exactly what the status on your application. And even once you have a trademark examiner assigned to your case, then the trademark examiner can also answer your question. Now, one of the frequently asked questions about trademark application, is to know how long does it take. Obviously, it used to take really not that long. It used to be like around 6 to 7 months. But for the last 2 years or so, there's been an increase of almost 50% in the number of applications registered, because now people have realized the importance of the intellectual property as far as an asset, right? And therefore, now the processing time have increased. It can go up to a year, meaning between the moment you file your trademark application and the moment it is assigned to a trademark examiner, it could be between 4 to 5 months. And then you will see at this point, obviously, assuming everything goes well, then if there is no problem, then the trademark examiner will review and send you actually a notice saying that there was no issue with this mark, there was no conflicting mark, because remember, we want to avoid the likelihood of confusion. And if there is no conflicting mark, now your application is moving toward, what is called, obviously publication. Here, I'm assuming that you're using your mark, because if you're not using your mark, they will be asking you, whether you are using your mark, whether you have what is called a statement of use. But if, let's say, you file under Section 1A, you're using your mark, then it's perfectly fine. Then at this point, it will move forward, right? And they will give you the notice of allowance, and then you will move toward publication. When it goes toward publication, you have to remember that there is a reason why it goes there, because third party have the right to challenge your registration if they believe that there is a likelihood of confusion. That's why there is a 30 days period where you have to wait for publication for any person that may believe that your mark is actually confusingly similar to theirs to come and raise that objection. Now, assuming no one come forward, this is great because you're getting closer to registration. If after 30 days, no one has actually come forward, then now you'll be going toward registration. USPTO is trying to move away now from the paper registration. They actually indicated that they will be issuing electronic, obviously electronic registration. It is less fancy than the big, obviously trademark that you can actually frame. But this is that's something that has been indicated by USPTO. But from start to finish, it may take about 12 months. Obviously, the head of USPTO has been very, very eager, and yes, is pushing, obviously, to have registration, to have a trademark register faster. And how? Because in a few weeks, they will be reducing the response period once you have an office action. Normally when an office action is issued, currently you have 6 months to reply. Now that's going to be reduced to 3 months, but you can always ask, right? Before the end of the 3 months, you can always ask for an extension. That is allowed. But what's the reason? Again, remember, the policy reason is what? It's because there are such a significant amount of application, right? And remember, the part of the Department of Commerce, you have to let the free market, you have this flow, and people want to protect their mark as soon as possible. By putting these 3 months, it put actually a little bit of pressure on the applicant, right? You receive an office action, then you need to move quickly, right? You have 3 months. You cannot, take too long. It's not going to be 6 months. But now we'll see, whether there are several measures, whether it will affect actually the processing time. If we'll make the processing time actually obviously shorter like it used to be, that remains to be seen. But basically, this is something that you want to keep in mind. I hope this was actually useful to you. Again, my name is Annie Koloko. I am a business attorney, a trademark lawyer, and I help small business and entrepreneur protect and grow their brand through trademark law. Meaning that if you have any question, we have quite a few information to help you through your journey that you may want to check them. You can look under the description here. Don't forget also to join our channel because we do provide information about business law, trademark law in particular, intellectual property. Obviously, remember, this particular presentation does not create an attorney-client relationship. I have to tell you that. It is for entertainment purposes, meaning that it's just not educational purposes, but it is not legal advice, meaning that really you're encouraged to definitely, govern yourself accordingly. But it is my hope to empower you, to provide you the tools in order for you, CEO, to be able to take your business to the next level. And protecting your brand is very important in order for you to grow your brand and really to be able to take your brand to the best, to have the best deal, and obviously to accomplish something that is beyond, even your imagination, but it is probably your vision. Thank you again for watching this. And if you have any question, don't hesitate to contact our firm or to leave us some comments, and we will be replying if we can help. Thank you again. Be safe, be well. Thank you. Goodbye.